Sorry
So
about
now that Delegate Embry is blessing us with her presence, we can get started.
that. I
We're
am here
going
as
live
well.
now.
Okay.
All right, welcome to the first meeting of the 2025 Civil Law Subcommittee of the Judiciary Committee. And we have a quorum, we're ready to go. And welcome to our new member as well. And we have, I'm hoping that we can vote on a few bills here. We have 6 up for conversations. Everybody should have gotten the list. I think what we'll do is I'll list up the bill. If anybody has any questions or concerns, obviously raise your hands. Yes, Delegate Williams.
Yes, thank you, Mr. Chair. I only have 5 bills, so I must be missing one.
Right.
Yeah, we have only 5 right now, Delegate Cardin. You're going to deal with Claire's next week.
Right.
She's not in this one.
I was told that I was allowed to at least let the group know to start thinking about it. That's what the chair asked me to do, is to just let everybody know that this is a bill that we want to discuss, so to start thinking about it. And that's House Bill 392. We're not going to do anything on it today, but I did want to just alert everybody of that bill. Okay. So yes, we only have 5 bills. We do have a few witnesses that are here on a couple of the bills. Holly, is the State Bar, States and Trusts here for questions if we?
Yes, we have Miss Thomas, I think, is in the waiting room. If we want to bring her in.
Wonderful. Well, why don't we start with House Bill 74. Why don't we go in order? House Bill 74.
So then for House Bill 74, you want to bring Lorenzo and Rebecca in?
Yeah, why don't we bring Lorenzo and Rebecca in for this bill? I know that they are not necessarily in favor of the bill, but and for those who don't remember, this is the Foley bill that Delegate Embry referenced last night. That is a little bit broader than her bill in terms of publication and notices of publication. Is there, do we have them in? Oh, yes, I see Mr. Bellamy here. And do you have your person, Lorenzo, here as well?
Yes, thank you, Chairman Cardin. I have Rebecca Snyder from the Maryland DC
Yep.
Press Association on as well.
I see her. Okay.
Okay.
So you asked for a few minutes to talk about a possible amendment. So can you?
Yes. So thank you very much, Chairman Cardin and members of the subcommittee. Lorenzo Bellamy Gen Group here on behalf of the Daily Record. So House Bill 74, which is Delegate Foley's bill that you all heard, and I know you heard last night Delegate Embry's bill. And Delegate Embry, thank you for your comments on the bill and our engagement on this as well. And I think there perhaps maybe we can have some additional dialogue, I think, between these 2 bills, but that may be for a different conversation. But I think that the door is possibly open, so I just wanted to extend that to you. For House Bill 74, what we'd like to see, Delegate Cardin, is, and I don't know if you have a copy of the amendment. I think I've sent it to 2 of your colleagues that I see. I think one is on Delegate Phillips, and I don't see Delegate Tolles on. But the amendment that we're looking at would basically just strike the word "or" where it says print or digital, and strike that to say "and." In the areas where it has both, and it's basically on page 2, line 16, after print, and on page 2, line 18. So we think that this would be more in line with the intent of the bill. We did talk to Delegate Foley. Rebecca Snyder can talk more about that, and she's okay with that amendment.
If I can jump in here, the purpose of Delegate Foley's bill was to mirror what we had done in House Bill 594 last year with Delegate Hutchinson. And when we got the bill back, House Bill 74 back, we did not catch that all important and or it does not mirror what what the bill that was passed last year actually said. So you can see later in that in the bill in the stricken language that's specifically about Dorchester County, you can see that the print and that we're looking for in page 2, line 16, you can see that that is the case. That is in statute already from last year's bill, page 3, line 13. So we wanted to make sure that the bill does do what it was intended and removes ambiguity about where how notices should be placed.
Okay. Delegate Embry.
Thank you. But that would, as it's currently written, it would allow publication in a newspaper that's purely online, and your amendment would restrict it to only print publications. Is that correct?
Not restricted.
No.
It would actually, go ahead. Sorry.
Go ahead.
Oh, sorry. Go ahead.
Rebecca, go ahead.
Actually, later in the intent of the bill is that it would be published in print and digital. In fact, if you look in line 20, excuse me, or line 20, starting in line 20 on page 2, I believe. Yes.
Yeah.
It talks about what happens if there are no print and digital publications. So this bill is meant to allow publication in the digital version of the customary publications that are already being utilized for public notice. And it foresees or contemplates a situation where there may not be a print publication. And in that case, if there is no print and digital publication, then the notice could go in a digital only publication. And so it's clear within the bill that that's what it contemplates. When you look at the Dorchester bill, it was very clear that it's supposed to be published in a print and digital vehicle. And I feel like that or makes it a little ambiguous. And that was against the direction. Bill drafting just made a mistake. That's all.
So I can ask,
Thank
maybe
you.
this is for Holly, but the intent of the bill right now, as drafted, is to give people a choice of online or print. And the purpose of the amendment is to say that they have to do it online, digital, and print. Is that as required by, as it would be required by statute?
With Lorenzo's amendment, it would do print and digital. I just want to point out that the Dorchester County bill was because Dorchester County did not have a print newspaper, and that is why it allowed for the digital. The background on that bill is a little bit different. It wasn't a drafting error, just for clarification. It was because that county did not have the ability to print in a newspaper because they didn't have a county newspaper. So just some background on that bill.
For edification, just so everybody knows, my background is a triathlon I did in Dorchester County, where I'm biking right there. So you can see that in my background. The fact is, though, that that if we pass the amendment and we pass the bill, what we're saying is that you now have to print anything that's required to be printed, notices required to be given, public notice. It has to be done if it is available, both print and digitally. And if print is not available, then you can just do digitally. That's what the intent of this bill is. I just want to make sure that's clear.
That's how I understand the amendment from, yes.
All right. Are there any other questions, Delegate Williams?
Thank you, Chair Cardin. So I see where we want to put the amendments, changing the ors to the ands. I guess what I'm not seeing is, and forgive me, so is it where starting, I guess, line 26 on page 2, is that where it's allowed to just do digital if print, I guess if print is not available? I just want to make sure I'm clear that digital is still going to be a viable
Delegate
option.
Williams, it's line 20.
Line 20.
Line 20.
20, page 2.
meet all the qualifications of paragraph 1 of this subsection. The advertisement. Okay.
I'm sorry to
Okay.
jump in, but can I clarify the Dorchester bill since I was deeply involved with that last year? The Dorchester County has 2 print publications. The problem that we were trying to solve is that they're weeklies rather than dailies. And so the commissioners were having a timing issue. It wasn't that they weren't publishing in print. They wanted the option to start the clock with publishing in the digital version of the print publication. And that's why it is written print and digital, because our members already publish in print and digital. Every notice that they have in their newspaper is also on their website. And so what this does is change when the clock can start running, that it says, because they'll always run in print and digital. That's what they do now. We just wanted to give them the opportunity to start the clock earlier.
We're going to spend just a couple more minutes on this bill. So Delegate Conaway, did you have a question? I guess not.
Yeah,
And Delegate
so,
Williams, do you still have a question?
yeah, so as Ms. Holly explained, that the way the bill is written now is the way that we want, because one place is not doing a certain type of publication. Is that correct?
No, I think I tried to, if my understanding is correct, and this is what the discussion should be about, the as amended, it would require that when publication notice, public notices is required, that it would be required to be done both digitally and in print, so that you have to do both. And the sponsor of the bill says that she's okay with that.
All right, thank you.
And Delegate Cardin, just to clarify, this is allowing for both digital and print. And Delegate Williams, if print is not available, like Holly just explained in line 20, then
Or is it saying that if you must do digital and you must do print? It's a difference, allow versus must.
I believe it's must, according to, as
yes.
amended, if the amendment passes.
Thank you, Mr. Chair. Thank you.
Delegate Williams, you still had another question.
Yeah, and I think Delegate Conway sort of hit on that near the end. So basically, the way I'm reading this is that if there is a print publication in the jurisdiction, the individual must use the print and the digital if they're required to do some type of legal notice in a local publication within that jurisdiction. So I guess my question, maybe / concern, for my legal practice, it's not a big, no, I won't say not a big deal, but, we charge the cost as a cost of doing business. My clients are willing to pay those costs for the print notice, as well as the digital notice. But what if I'm pro se and cost is a concern for me? Am I forced to do print even if the digital is cheaper, but I don't really have the money to pay for both print and digital?
So this is a question really for Holly. Holly, if we didn't pass the amendment, confirm with me that you are incorrect, Delegate Williams. If we did not pass the amendment, you would be able to do one or the other. But if we pass the amendment, you're required to do both.
That's right.
Okay. Delegate Grammer.
Thank you, Mr. Chair. And can you articulate to me again what the purpose of both is?
I think that's for Ms. Snyder.
Thank you. So the purpose of both is really more of a timing issue. So to Delegate Williams' point as well, you're already placing in print, the clock starts in print. That's the way the statute is written. This bill would allow, and you're also already getting print and digital. It's a blended product. It will most likely stay a blended product until necessary. What this is saying is that any notice from government that's placed by government, so this is really only for county and municipal governments, can be placed beginning with the digital version of that print publication first. So it erases the timing issue. It doesn't change that you must use a newspaper of general circulation, and I think that's really clear in the bill. it does not change that it doesn't say you can do digital only necessarily, or the intent of the bill is not that you can just do digital only. It's that it goes in that blended rate or that blended product, and it erases the timing issue for jurisdictions with weekly publications that might be missing, that might have the timing issue.
Okay.
Thank you.
Is there any other comments? Yes, Delegate Embry.
I'm sorry. I just want to make sure I've said this. This does mean that all online publications do not have unless they don't exist, unless there's no print in the locality. So Baltimore Banner, countless other new news organizations that do not have a printed hard copy will not be allowed under this bill to provide notice. And as Delegate Williams said, online is cheaper. So I still think the bill is a big step in the right direction. I think it is the intent of the sponsor, so I understand that, but I just wanted to put that on the record.
Okay. Thank you. And Delegate Conaway, last comment, and then we're gonna.
No, I just have a question because
Sure.
it's not clear to me whether it's government only, which was stated, or would people like the Banner would they have to comply with this?
It's Delegate Conway, it's a county or municipal corporation, so government only.
Right, not the Banner, right?
The Banner would not be able to take legal notices until there is not a print publication in one of the jurisdictions that they serve.
They would not be able to take the notices.
Correct.
Okay. Thank you.
Okay. Delegate Embry, did you have any other comments?
I mean, if we could hold it and have more consideration about the amendment and the impact on non-print, but I defer to the committee.
I'm going to check, and I know that I believe, Mr. Bellamy, of course, you're the most honest, decent person, but I'm going to check with Delegate Foley, make sure she's okay with the amendment, and we will take this up for a vote next time. So, but thank you. It sounds like we're on the right track. Everybody seems to be on good terms on this, and I think we're gonna figure out a way to make it work. All right. Thank you very much.
Thank you very much. Thank you, committee members.
Thank you. Thank you, everybody, for your comments on that. Okay, let's go to maybe a little less controversial. House Bill 88. All right, I'm pulling mine up right now. All right.
And we have Ms. Thomas here.
Yeah, this has a sponsor problem, but besides that, this bill, this is the
favorable. No, no kidding. No kidding.
Okay. So we did some decanting work last year. This is not, it did not have any controversy or questions when we presented it. If anybody wants to talk about what it does, I'm happy to go into that. Are there any questions? Let me look real fast. Yes, Delegate Conaway.
Thank you, Mr. Chairman. You know I have to be exempt on this.
That's fine. If you decide you want to be exempt. And for edification, because Delegate Conway is related to a register of wills, he takes the rule on estates and trusts. I don't think that DIA would require that, but that's okay. If you feel that's important, you should do that. The bill deals with provisions in the Maryland Trust Decanting Act. I think that we had testimony in favor of this from the Bankers Association as well as from the State Bar. Does anybody have any questions? The State Bar is here with us, Ms. Thomas, who is incredibly proficient, much more so than I am on these matters. Anybody have any questions for her? Is there a motion?
Move favorable.
Second.
Second.
All right. I normally would do it the opposite, but I'm gonna do it the way that I think that's Robert's rules of procedure, and ask all those in favor, either raise your hand or raise your virtual hand. Any opposed? All right, that was easy. Okay. House Bill
Oh,
146.
I wanted to be noted as voted yes on that one. Sorry.
Very good.
I
Thank
had
you.
to step away from my desk for a sec.
House Bill 146. Authorizing a trustee of a trust to resign and give notice. Let me just pull up my notes on this so that, because this one's has a little bit more to it than the previous one. Authorizes a trustee to resign without seeking court approval, as long as notice is given to the beneficiaries, the creator, and any other fiduciaries in the trust, or anybody who has an interest. Miss Thomas, is there anything that we need to know about this legislation that didn't come out in the hearing?
Not that I'm aware of.
Okay.
This applies just when a trust does not specify how a trustee can resign. Under current law, the only way to do it is through a court procedure. So we're adding an additional way for a trustee to be able to resign if the trust agreement does not contain that information anyway.
Okay. And really, and what it does is it says that as long as you're giving notice to all the people that need to know, that you can do it. You don't need to go through an official court procedure. Is that my understanding? It creates efficiency as well as reduce costs that would be incurred by the beneficiaries of the trust.
That's correct.
Okay. Yes, Delegate Williams.
Thank you, Delegate Cardin. Thank you, Ms. Thomas, for being here. I generally don't have an issue with the bill. I guess my only question is, if I have a trust that's recorded, is there an obligation for the trust to record an updated version of the trust and land records, if that is indeed the case when the change is made?
So typically, it's
If I have property that's held in the trust,
right. So
usually that's reported.
typically, if the trust is recorded in the land records, then it's really only once the trust or the trustee of the trust is trying to sell the real property that they then also submit the documentation that shows the transfer of trusteeship to a different person. So usually that occurs upon sale of real estate versus automatically recording it in the land records.
Got it. Okay, that's my only question. Thank you.
Okay.
Delegate Phillips, you have a question?
So in this one, I was really curious. So a trustee resigns and there is no provision for a substitute trustee or an alternate trustee. What happens with that trust?
So we have a provision within the Trust Act that addresses a vacancy in trusteeship. And there is a specific order of who is eligible and who can either nominate a trustee to fill the vacancy, or if it needs to go to a court proceeding to do that.
But correct me if I'm wrong, Ms. Thomas, but in this legislation, what we have is if somebody objects to the resignation, then you wouldn't be able to proceed using this instrument. Isn't that right?
Correct. There would then need to be if they object, there would need to be a court proceeding to have the court order the designate who or approve the resignation of the trustee and likely, unless the document specified a successor, nominate a successor or appoint a successor as well.
Has there been a situation, per Delegate Phillips' question, has there been a situation where somebody resigns without any express knowledge of who the next trustee might be in the documents or agreed upon, and nobody objected?
I have not had that particular situation occur. There is somebody who either the document has specified to serve or is nominated by the person who is either under the statute or under the trust document can appoint the successor trustee. So if there is no one, you usually petition the court to appoint a successor, and any of the interested persons can be appointed in that role.
So who is the person that would, so do I have an affirmative responsibility as the
Fiduciary.
Resigning trustee?
resigning trustee to ensure that there is someone who will be appointed or to initiate an action to make sure there is a successor trustee? Do I have
No.
any responsibility? Seems to me I would have some responsibility to the trust.
So typically, the trust document can name a successor.
But I'm saying if it does not.
Okay, then under our Trust Act, any vacancy that happens is filled either in accordance with the terms of the trust, of a person appointed. If not, then appointed by unanimous agreement of the qualified beneficiaries or appointed by the court. So all three of those options are available in that situation.
Okay. All right. So it doesn't relieve me, particularly if it's a recorded trust, of notifying that I'm resigning.
No, you have to notify.
Okay.
It
Not
does
just-
require.
Not just the interested parties, but I might need to notify the court if it's recorded.
No, you would not need to notify the court unless they have some sort of ongoing jurisdiction over the trust, which typically only happens, very rarely, and under testamentary trust, that there's some extraordinary reason that there would need to be continuing court oversight of that trust.
Okay. I got it.
Okay. Any other comments, questions? Is there a motion?
Move favorable.
Is there a second?
Second.
Great. All those in favor indicate by either raising your hand or putting up your little thing, I think the delegate grammar is not available for this one, so we need.
Conway.
Anybody and Delegate Conaway is taking the rule. Anybody opposed? Great. That bill passes as well. Great. We're now on to House Bill 249. This is the real property bill from Palovich Carr that prohibits governing body of a county or municipality from enforcing local law or ordinances that, one, establish a threshold of requests to summon law enforcement or emergency vehicles, or two, otherwise penalize or authorize penalty against an operator, owner, occupant, or tenant for an act summoning law enforcement emergency services.
Delegate Cardin, may I give a little bit of background on this one?
Absolutely.
Okay, so it was the intent of the sponsor last year with chapter, in 2023, chapter 768 and 769. When she drafted the bill, she wanted it to prohibit enacting and enforcing local ordinances that deal with summoning law enforcement. When the bill was passed, it only prohibited enacting. So these local municipalities can still enforce local laws that are still there. This is cleaning that up and actually doing what she wanted the bill to do, which was, if you look at the bill, it's line 20 and 21 on page 2. It's prohibiting a county or municipality from enacting or enforcing local laws. And then it goes down through through the law enforcement summoning and all of that. So this is fixing a presumption that should have been there initially.
So it's that there may be, we've outlawed the ability to do it, or to create these laws. But if the laws are still in the books, we didn't
Exactly.
say that those laws have to be taken away or revoked or however, I don't know what the right term is. And that's what this does. Any questions? Yes, Delegate Schmidt.
Thank you, Chair. Was it edited or modified, amended in the Senate? Is that what did it, or was it just a language issue or error from 2024?
I believe it was just an oversight, and we figured it, I guess they figured it out based on the counties can't enact it, but they're still enforcing laws. Some counties are still enforcing the laws that are already on the books. And it was an oversight that should have been in the bill when she initially introduced it.
Got it. Thank you.
You don't know what you don't know until you find out that you didn't know it. All right. I don't believe, again, this is something that we already decided as a policy that it's a good idea. I believe that it was a unanimous vote last year. Holly, is that correct or not? So yes.
Yeah, I'm pretty sure.
This was not a partisan. We just want to make sure that our local law enforcement are behaving themselves. Yes, Delegate Tolles, while we're waiting for Holly to answer that question.
Yes, Mr. Chair, thank you. While we're waiting for Holly, I stepped away, so I did want to be in affirmative for your bill. I always like to make sure I keep you happy.
I thought you did that. You stepped away on purpose.
No, I wanted to make you worry a little bit, but I always like to keep you happy. So I definitely want to be a yes for HB 146.
Thank you. We'll make sure that's noted.
Thank you.
Okay. So can I get a motion on House Bill 249?
So moved.
A second?
A second.
Great. All those in favor of the legislation, raise your hand or put up your little digital. Great. Anybody opposed? Wonderful. And we got a Conaway on that one too, guys. Look at that. Okay.
Yes, you won't get me on the next one.
Last one for today's discussions. And again, just to remind, commercial, think about 392, and we can discuss it next week. Okay. 261. Let me pull up my notes.
Do we have Alexis with us?
Alexis isn't here.
Okay. She wasn't able to join us, Delegate Cardin. So I don't know if you just want to talk about this and we can bring it up next time, or how you want to handle it.
This is Alexis Rhodey. We couldn't get her. Bill well, we can at least discuss it, and then if there needs to be a motion, or we'll deal with that as it comes up. This bill prioritizes the payment. Oh, right. Okay. Yes, I do want to discuss this. I'm not sure we're ready because I do think I'm going to be crafting a possible amendment that I just already discussed. Okay, so this will change the prioritization of child support. So if you will remember from the hearing, there are a list of like 16 different priorities on who gets paid out of an estate. And the last one is like everything else. And child support is in the everything else.
Correct.
And so I brought up with Delegate Forbes late on a Monday night, a few Monday nights ago, I asked her, well, what if the decedent is 80 years old and the unpaid child support is on behalf of a child who is now 58 years old and the mother is already dead? So, I mean, what if it could happen? Why should that go over, creditors or car payments or other things that might want to take priority because they are things that they're dealing with right then and there. So, so I had suggested maybe an amendment that said that if the child is 18 or under at the time of the death of the decedent, then it can be prioritized up higher, and we can just talk about whether it should be at a certain number 6, number 2, whatever. But why should a person get why should this, whether it's the state or the guardian, it's not the, remember, it's not the individual, it's the, could be the mother of the, whoever is supposed to get the child support, should be getting it if the person's already 28, 35, 50 years old. So anybody, any thoughts on that? Delegate Tolles, do you have a thought on that?
Yes, I do. Thank you, Mr. Chair. I think you bring up a compelling argument, and I kind of concur with that. I would like to add a sort of twist to that, that you do have, you know, children that are still in college. So perhaps adding that, you know, up until 21 or 22, or even post-college for most child support payments, they do go up. They will extend if they are in college. They can stop at 18 if they are not in college, but if they're in college or technical, some type of trade school, then it usually is extended. So I don't know if you would be
No,
open
it's
to.
a great point, and my kids aren't old enough to go to college yet. So I'm thinking, well, if they're in college, maybe that's just something. Yeah, yes, the great point. Holly, we can talk about that in the amendment, see if maybe 21, 25, whether there's a proper age, but maybe not just carte blanche. It should automatically be prioritized. Yes, Delegate Embry.
Just a, okay, we could
I'm
talk.
sorry,
more.
Delegate Tolles.
Yeah, just really quickly, we could, if you just refer like to some of the child support language, it says, you know, maybe into college or 4 years after or something like that, but I'll be happy to.
Yeah, no,
Yeah.
I think that's
Yeah.
great.
Okay, thank you.
Definitely think about some language. That'd be
Yeah.
great. I would love that.
Thank you. Okay, I will. Thank you.
And check it out with Delegate Forbes as you think about it. So make sure. Yep, Delegate Embry.
I just wanted to, I mean, maybe Alexis is the best person to answer that, and I can reach out to her, but exactly what does happen? Because I think I would still, for me, I'd rather, if it goes to the child or caregiver, I'd still prefer that over maybe a creditor. I just want to make sure I understand what happens if the child is over a certain age.
What if the creditor is like your synagogue or your church?
Well, funeral expenses are higher than child support. So,
Yeah.
But anyway, I just want to better understand it.
No. Yeah. So we'll Holly, maybe we can I'll call Rhodey and find out, and we can.
Yeah, she just unfortunately had another meeting, so she was going to try to pop in, but just couldn't make it work today.
Yep.
So we can.
That's a great question, though.
Yeah.
Okay. Yes, Delegate Phillips.
So I'm just thinking about how some of this works today. And I just had a matter that kind of has me thinking about this. And it had to do with an estate and money that was owed to the state because of a really old arrearage on child support. And so the state took that money, and this was really, really old. And so I'm thinking, if there were no indebtedness, why shouldn't the child get that money, even though it's, or the who was intended to be the beneficiary get that money? And I know however old, they didn't get it when they were younger, but they were supposed to get it. And so I know it may seem like a windfall, but philosophically, because the state's going to get it, if there were not an obligation, right? If there were an obligation and the state still had that outstanding and they were still in the collections, the state would get that money.
Mm-hmm.
So do we not provide the child with the benefit of that money?
Well, let me ask you, can I just ask you a question about that? So what if it's not the child that gets the money? So if the state gets the money, do you think we should waive it? If the guardian or the mother or the father would
So
get
it's the mother, right? And
to benefit the child, right?
it was to benefit the child, so that mother in some way, shape, or form fulfilled that responsibility without those funds, right? The mother fulfilled those responsibilities without the funds that they were potentially due. And so now those funds have come due, but they made out without those funds for 18 years. So just another way to think about it. So I need to think through this one. Right? So it's not necessarily like the
I
mother's
agree.
getting
So
it's
but
not
the
like the
question,
guardian is getting a windfall. The guardian had to manage without those funds.
Oh.
Now those funds become available. Wouldn't the guardian be just as
but that's not a change in law. They still, in theory, if the decedent has all the money to pay off everything, that money will go to them now. The question is whether it goes to them if he only has a limited amount of money. And this is a policy, you're right, it's a policy question. I'm thinking, somebody, he owes a business that he took a loan out of his business. Should he have to pay that loan back to his business before he pays 18-year-old child support, where the son is a CEO? I'm not saying that this is necessarily the case, the CEO of a company and making millions of dollars. Who knows? I mean, it's possible that that the person does merit it and should be able to afford to have it. It's also possible, sort of like, I think it's a question on each case could be different. And like,
I don't know. I mean, I think if we're going to prioritize child support, you prioritize child support, and whoever, whatever the status of that individual is over time, doesn't take away from the standpoint that child support was something that should have been prioritized.
No, but it might take away if let's just say this for the sake of argument, that you were the benevolent dictator and you looked at the list of all the places that he owed, and knowing sort of where this person who's due child support 20 years ago is versus where he was, should that make a difference in your decision as to who gets the money? I'm asking you, I mean, it's a question. Should it make a difference or not? Do you want it to, or do you not want it to? And I mean, there are lots of different creditors. Delegate Embry was talking about creditors as if they're terrible people, but all these people are creditors. That child who didn't get their child support is a creditor, right? I mean, technically that's what they are.
Right.
So the question is, do we value them more than we value
medical expenses, then we value wages and salaries, then we value public assistance to adults, because that's what they move up ahead of.
Right. It's a policy question. It's something to think about. So we'll get some of those questions answered by Alexis, and Delegate Tolles and I maybe will work on an amendment and we can tell you, look, I don't think this is not like something that's going to have a tremendous amount of emotional strain on any of us. I mean, I think it's just a policy question. Yes, Delegate Williams, did you have a question?
I was going to ask the question, but I guess it could really wait till next week. I was just curious about what the language of your amendment will be, but I guess that's also something that we could just discuss when we meet next.
Yeah, I was thinking, and we can talk about it later. I was thinking something to the effect of that you could put it in, like, let's say number 6 is, I think, what Delegate Forbes had suggested. Number 6, and I was going to say the child support, if the children are 25 and under at the time of the death, something to that effect.
Okay.
And then it would then go back into number 16 if they're over 25. That was what I was thinking. And that kind of, I mean, I think that it's a policy question between Delegate Phillips' perspective and mine. So.
Okay. All right, sounds good. Thanks.
Great. Thank you guys very much. Is anything else for the good of the order before we got 10 minutes to eat lunch, although Delegate Embry's already doing that.
I think we're good.
Thank you.
Thank you all very much.
Bye-bye.
Delegate Phillips, there's a CCBC lunch over at the Maryland House, by the way.
I know that I think we're both missing.
Yeah, I ran over there and said hello to Dr. Kurtenitis, but I didn't really have, I grabbed a couple of hush puppies. So if you want to go over there,